Welcome to Eldercare Illuminated, Torchlight's caregiving podcast. Eldercare Illuminated addresses the ins and outs and ups and downs of caring for your loved ones. Join us for interesting conversations with eldercare specialists, geriatric care managers, attorneys, and ordinary people with extraordinary caregiving experiences.
Welcome, listeners, to today's episode of Eldercare Illuminated. I'm Lenore Tracey, your host, and the Eldercare Practice Leader at Torchlight, which brings this podcast to you. Today, I am happy to welcome back one of our favorite guests, Cathy Sikorski. Cathy is an elder law attorney in practice in the state of Pennsylvania and a writer, family caregiver extraordinaire, a humorist, and a person who is going to share some really important stuff you and I need to know. So happy to have you with us today, Cathy.
I'm always happy to be with you, Lenore, but one of your favorite guests. Thank you so much. I'm honored.
You are. Today, we'll be discussing the difference between an elder law attorney and an estate attorney. There are some important distinctions we all need to understand and keep in mind as we care for a loved one and prepare for our own old age. And yes, I said prepare for our own old age. For ourselves and for our loved ones, the only way you and your loved ones get to have a chance at getting what you want in your so-called golden years is to think about it and plan. Cathy, as we prepared for today's conversation, you graciously sent me some information ahead of time. And the first point you wanted us to discuss was live people versus dead people. Exactly. Obviously, I am curious. And why did you leave out zombies from our discussion?
Truthfully, because I didn't even think of it. So I'm going to have to add zombies in. I just don't know exactly where they fall. But let me tell you why I say live people versus dead people. It's kind of the most significant way to explain to someone the difference between an elder lawyer and an estate lawyer. Elder lawyers deal with live people and their problems. So we deal with, of course, as you said, the aging process. We deal with Medicare, Medicaid, powers of attorney, living wills, Social Security, things that live people have to deal with when they have problems, especially as they or say their parents get older. Estate lawyers are for dead people. I mean, obviously, you're not dead when you go to an estate lawyer, but the whole point of going to an estate lawyer generally is to have them prepare for your death. What is it that you want to happen with your stuff and your money and your estate when you're dead? And that is classically live people versus dead people. What's beautiful about this is it's also a great way to explain power of attorney versus will. And I know we're going to get into that a little bit more in a minute, but it's the same concept. Powers of attorney are for live people and wills are for dead people. Because once you die, your power of attorney dies with you. It's not even like a zombie. It can't come back. It has to be over and done with, and your will takes over. So okay, that's why I said live people versus dead people.
So if we don't understand this by the end of our conversation here, it's possible that you don't have that we won't have put in place the right tools. We might only have dead people tools while we're still alive, or we might only have live people tools and then try to do stuff when we or someone else are dead. So help us.
Exactly. And the lingo is critically important. And I know people get frustrated because, legal lingo, legal language is not their tools. But you need to understand this so that when you're either having a conversation, either with your professional, your lawyer, or even with your mother or your father or your spouse, that you understand what tools you're talking about. So first of all, let me just say that I love estate and elder lawyers. We're all wonderful people and we all do really good things. And this is not to disparage anyone in their work. It's just so that we, the common man who use these attorneys, these professionals, especially in this aging crisis, know who we're looking for and what they can help us with. Okay? So here's the tools. So an elder lawyer will absolutely deal in powers of attorney, healthcare proxies or healthcare powers of attorney, and living wills. Let's start with those three because they're probably the most critical. And the 30-second definition that I always say, Lenore, of a power of attorney is that document that you sign over to give your agent, a person that you trust, either complete financial authority to act as if they are you, making all financial decisions, or complete healthcare authority to act as if they are you, making all your healthcare decisions. So there's two kinds of powers of attorney, or as you know, some people call healthcare proxy, but both of those documents, a durable financial power of attorney and a healthcare power of attorney, are where you give the power to an agent to act as if they are you and make all these important critical decisions while you're alive and disabled.
Okay.
So that's what an elder lawyer will do. They will make sure that your state's rules are followed about these documents, doing what you want the document to be able to do when you're incapable of doing it. And as you know, it's an extremely powerful document. You're handing over a lot of authority. And so you must choose, but you must choose wisely. So that's our first little set of tools in our toolbox. The living will, which is such a misnomer. I don't really know where it got that name. It's sometimes also called an advance directive. It's the same document. It's the same concept. It's kind of like when Sean and P. Diddy Combs have the same name. It's the same thing. Okay? It is a document where you are telling someone, if I am in a permanent vegetative state, what do I want done? And many times this is a document that says, I don't want chemotherapy. I don't want a feeding tube. I don't want a respirator tube. I do want palliative care. I do want to be kept comfortable. And you sort of either check the boxes or, you've said something along those lines. That's what a living will or an advance directive is. Also,
Cathy?
Yes.
Cathy, what if you're temporarily incapacitated?
That's a really good question because this living will is only for a permanent vegetative state. That healthcare proxy that you filled out, that's for temporary incapacity. That's the whole difference. That's a big difference too because people get scared with these living wills. They think, oh my God, I'm going to go in for wisdom teeth to be pulled out and somebody's going to donate my organs.
That is a terrible thing. That should not happen.
It can be, except it shouldn't be and it won't be because the whole point of that advance directive / living will is only, quite frankly, if you're never waking up. And as you can see, my live people versus dead people conversation, I'm pretty blunt about using language to help people understand this. So a living will is a pull the plug or don't pull the plug document. That's really what it is, Lenore.
Or put in a feeding tube or don't put in a feeding tube or,
all of those things for, do you want to extend my life even though it is very, very obvious that I am not waking up. I am going to be permanently in this coma-like state. And everybody has different ideas about what they want, and that's fine.
So a person could say, I do want a feeding tube. I don't want you to turn off the machine. So people should be clear on that.
Yes, and I absolutely have clients who have done that. And I have clients who one spouse wants the feeding tube and the other one doesn't. And that's okay. But make sure you choose someone who's going to make those decisions, who understands that that's your decision, not their decision. Your decision. Right. And that's what the beauty of that document, truly, Lenore, is that you have written down your decision and it gets your person in charge off the hook because they can say, I didn't decide this. Mom decided this. We're going to do what mom wants. I might not even agree with it, but she decided it. And that's why we're doing it.
And that is a gift to that person because it is a burden to make a decision that you really, if you don't know what your loved one, what your spouse or your parent or your sister wanted, and then there you find yourself, I have to make this decision. That's rough.
It's not even that it's just a burden, which is true. It is a huge burden, but it's that in my experience, everybody comes out of the woodwork with an opinion when you're faced with this burden, and you can't please everyone. You're going to find that you can't please everyone because the opinions aren't going to be 100% all on the same page. And so there you have this piece of paper that says, okay, we have guidance here. We're going to use it. It is very, very much a gift. Exactly what you said. Yes, I couldn't agree more. So that's the next set. And then another tool is trusts. And when I was discussing this with you, I wrote so many kinds of trusts because there are, in fact, so many kinds of trusts. I guess my first word of caution is you cannot entrust the creating of trust to just anyone. This is really a complex legal matter that gets set up between you and your attorney to do maybe a special needs thing because you have a child who is, disabled permanently and you want to take care of them for the rest of their lives, no matter what happens to you. Or maybe you know that you have a chronic illness and so you're trying to do some Medicaid planning so that you can leave some money to your heirs. Or maybe you have a family member who is, pardon the pun, untrustworthy. And so you want to set up a trust so that their money gets doled out accordingly so that they don't run out of funds. So there's a billion reasons and ways to use a trust, and it can be for a live person or a dead person. That's the complexity of trusts. And that's why I would not entrust just anyone to do that. I would certainly not leave it just to my financial advisor. I see a lot of financial advisors creating trusts, and I'm not saying that that's necessarily wrong, but I would definitely have my elder and or estate attorney in on that conversation, or at least attending to that conversation, because trusts are complex vehicles to help you do complex financial transactions. Perhaps if you're a live person, perhaps if you're a dead person.
Do both elder law attorneys and estate attorneys do trusts?
They do. They truly do. And you may need a trust as a live person and not a dead person. And you may need a trust as a dead person and not a live person. So we're going to get to this in a minute, but how do you find the attorney who's right for you? And we're going to talk about that.
I want to add another complication. Could you need one kind of trust when you're
alive
40?
And one when you're dead?
When you're alive and when you're dead, or one when you're younger with a young family, and one when you're older with an old family.
Well, aren't you just leading right into my next conversation? You're really good at this, Lenore, because now
thank you.
That's actually kind of a will question. Okay. So yes, you may need a trust when you're alive, and you may need that if you're a young family or an aging family. But wills are often where, especially young families, create trust, because if something happens to a mom and dad, they want to make sure that their kids have money as they're growing up. That's a very typical trust that lawyers put into a will for a young couple. And so wills are also a very complex and unique kind of a legal tool that are, I want to say, exclusively the realm of estate lawyers. But again, when I tell you about how to pick your lawyer, you're going to say, okay, wait a minute, maybe my lawyer can do both. But this is when I want to talk to you about wills, which is the language that we use around a will. We just discussed how a power of attorney, whether it be financial or healthcare, has an agent. That's what you're naming, an agent to take care of your affairs. A will has an executor. That's the person who takes care of your affairs after you die. And so I often hear this conversation. I'm my mom's executor, so I can take care of all of her affairs and we're good to go. And I say to them, well, that's true if your mom has passed away. Is that what we're talking about? And they say, oh, no, she's in a nursing home. And I have to make them understand that executors, like estate lawyers, are for dead people and agents are for live people. So if you're an executor, you can only take care of someone's affairs after they have passed away. So you have to know that that's the language. Executor is only for live people. If you are an agent, you can only take care of someone's affairs while they are still living. So let's go back to your question, which was, well, what about those trusts again? Those scary trusts that seem to be everywhere. Could I need them when I'm young? And then could I need them when I'm old? And the answer is yes, 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 and yes. But here's the thing. I like to say, I have all these young couples who come in, they do a great will, they put in a little trust there for their children, they make sure they have a guardian that they've chosen, and they take that will and they fold it up and they put it in that underwear drawer next to their nice, sexy underwear. And they're going to pull all of that out one day. And two things happen. They don't pull out the sexy underwear and they don't pull out the will. And I need you to pull out that will and look at it, because I don't care about your lingerie, but I do care about your will. And if you have a will and your kids are now 30 and 35 years old with children of their own and you haven't changed it since they were toddlers, you need to look at your will. Things change. People change. And you need to look at all of these documents every 5 years. That's my suggestion. So let's talk about attorneys and who uses which tools. Because really the question is, do I look for an elder lawyer or do I look for an estate lawyer? And I want to tell you this. Many, many elder lawyers are also estate lawyers. And in fact, they probably started their practice as estate lawyers or doing that kind of work. Because in the world of the practice of law and the bar, elder law is fairly new. It's maybe 25 years old, which is actually a baby. Estate law has been around since King John and the Magna Carta, where people could actually start giving their own land away. So we learn about estate law in law school. They are just starting to teach some elder law in law school. So many estate lawyers start out that way, and then they hone their practice to estate and elder law. So if they do both, yay, you win a prize, right? If you've already gone to an elder attorney, and they do Medicaid planning and they do powers of attorney, but they don't really talk about what happens when you die, then hopefully they'll send you to an estate lawyer, or you need to find an estate lawyer to discuss what happens to your stuff, your estate, your money after you die. And I'm hoping that you're going to good lawyers who will say to you, you know, we don't do that, but here's a professional who does. And the same is true for estate attorneys. Some of them do not practice elder law. They don't do Medicaid planning. They don't know that powers of attorney have to have super important language that has to do with what happens when somebody goes into a nursing home to protect the other spouse. And so you need to ask them some really important questions to find out, do you do both of these things or do you only do one thing? And if you do one thing well, then let me go to someone else who does the other thing.
I think you have brought up a really important point, and this may just be a little bit of a side road here. People are very reluctant to ask professionals questions about their expertise. We might see this even more significantly on the medical side.
Yes.
People don't want to say to their doctor, well, you think I should have this surgery. How many times have you done this surgery?
Right.
Are you the best in the area? But we all need to be comfortable with asking questions of professionals. We need to ask them in respectful ways. And I feel like if you ask a question and the person you're talking to is affronted, that you might say, is this your area of expertise, or how long have you been doing this? That's a red flag for me anyway. What are your thoughts about how we have these conversations with the professional?
I so love that you brought this up, just in general, honestly, because what you and I are talking about is how do we empower people to get the right tools that they need in order to navigate through this caregiving and aging world, right?
Yeah.
And as you and I both know from hard personal experience, Lenore, this aging and caregiving world is not easy. It has all of its own stumbling blocks, and we are constantly on the outlook for tools to make our life easier, but nothing is worse than coming up against either not having the right tool and you can't get it. For instance, if you didn't get that power of attorney, and I'll talk about that in a minute, or talking to someone who you think is a professional who ends up not helping you and just ultimately spinning your wheels, right?
Right.
So the wrong doctor, the wrong durable equipment people, the people who won't come fix the wheelchair, right? I mean, this is really shark-infested waters, isn't it?
It certainly is.
So 2 things. Number 1, I'm hoping that certainly as a caregiver, the longer you do this, the stronger you get, right?
Yeah.
Because you do, in fact, realize you're an advocate. I think if I could teach caregivers one thing at the outset, I would say that word caregiver is really code for advocate. You are now an advocate. Look at yourself in a completely different way. Yes, you're a caregiver. You're doing all the kind and wonderful and comforting things, but you're an advocate. An advocate means you have the right to ask important questions of people who are professionals. And I agree with you. If they get affronted in any way or insulted just because you're asking questions, then that's not the person for you.
And you have the right to say no and to say, I think this is not the person for me. I'm going to find another person.
Oh.
And that's hard.
Yeah, I know.
Yeah.
And it's so funny that you bring up the medical issue, because my mom was literally telling me a story about one of her friends, and my mom's 91 and super healthy. I'm very blessed. And one of her friends who went to a told the doctor, because the pharmacist told her medications were a bad mix. And she went back to her doctor and he said, no, I know what I'm talking about. And she said, I'm going to get a second opinion. And he said, well, you go right ahead, but you're going to find out I'm right. And of course she found out he was wrong, right? And the doctor said, no, your pharmacist is right. You cannot be taking these medications together. And she went back to her old doctor to report that. And he was adamant that he was right. So that's when this friend of my mom's, who's 91, who was probably, in fact, I know she's an older lady as well, needs her advocate, whoever that may be, her son, her daughter, her niece, whoever that caregiver is, to say, Mom, we're switching doctors. This is not the position for you. So.
And that's hard to do, but you got to do it.
It is. And I would say, so how do we empower people? I guess the first thing is, number 1, tell them they're advocates, which we just did. And number 2, give them some of the questions they can ask, right?
Okay.
So we're going to do that. And we're going to start with the fact that every state has different rules about powers of attorney. So some states might have similar rules, and some states might have completely different rules. And there is a Uniform Power of Attorney Act where every state sort of plays that game. But because every state has different rules ultimately, if your power of attorney is just a general document that doesn't give you your state-specific authority, you could find yourself in a place, especially as a spouse, where you would be unable to get money, say, from your spouse's retirement accounts in order for you to survive because you didn't have your power of attorney set up correctly. That's an elder law issue. So I would ask this question to my elder/estate lawyer or general lawyer, whoever you're going to. Does my state or our state require unlimited gifting language? And that's the key. Unlimited gifting language for my agent in my power of attorney to be able to access my IRA, my 401k, or my retirement funds. I'm going to repeat that. So if somebody's writing it down, they know. So does my state require unlimited gifting language for my agent in my power of attorney to be able to access my IRA, 401k, or retirement funds? And just a tiny little background about this question. The reason you want to know that is if my husband goes into a nursing home and I am a typical baby boomer and now even Gen X spouse, we're finding out that the women still stepped out for caregiving. They stepped out to raise children. My husband has the big, huge 401k that we use now in our retirement for our living expenses. He goes into a nursing home and strokes out. In Pennsylvania, if I don't have unlimited gifting language in his power of attorney, I, as his agent, cannot access any of his money in his 401k for my expenses.
Oh my.
Right? Scary.
Yeah.
Super scary. That is not true in every state, but it's true in a lot of states. And so you need to ask the question. And to be honest with you, it is the highest level of authority. So if you don't need it and you're in another state that doesn't have it, who cares? It just gives you more power. Mm-hmm. We love more power, like Tim the Toolman, more power.
A question related to that. Are you going to talk about springing powers of attorney versus
I can.
Whatever
They're not.
Okay.
Spring powers of attorney was a very old-fashioned document that we learned about in law school. That's how long it's been around. And the concept is this. The power of attorney doesn't spring into action. It's not useful or usable until a certain event happens. So the power of attorney might say, upon my permanent disability, this power of attorney now springs into action. And that's a springing power of attorney. I don't write those because I give the authority right away. The reason I don't write those is because who decides what permanent disability means when it's going to spring into action? And maybe you want that because you don't have a spouse. You only have a niece who lives 10 states away and you don't want her to have authority until you need somebody to have authority. So there are times certainly when a springing power of attorney might make sense. And that's a conversation that you need to have with your elder lawyer. That's absolutely a good question because there's pros and cons for that. Maybe we should say that the opposite of a springing power of attorney is a power of attorney that goes into effect immediately upon signing. That's the difference.
Okay.
So question number 2, does my state require, because remember, each state might be different, specific language in my power of attorney for my agent to be able to change beneficiaries on any account that I have that has a beneficiary after I am disabled? The reason you want to know that is many times people have gotten into a second marriage or they left a life insurance policy to a child who predeceased them or something along those lines, and they never changed a beneficiary. This happens more often than I can tell you. I tell them that 5-year checking rule. I say, check all your beneficiaries when you're checking your will, etc. So if you haven't checked your beneficiaries in 30 years and you have a problem, or your spouse notices it because you forgot to change your work policy from your first wife to your second wife, if you have language in your power of attorney that allows your agent to change beneficiaries, then he or she can do that. If you don't have that language, it is very unlikely you will be able to do so. And it sticks, and it will never go away. You can't fix it.
Good point.
So, would you like me to get to my third question?
I would.
Okay. This is a question that is more on the estate side, which is, why isn't a simple will right for me? Why isn't a simple will right for me? And so that sort of goes back to our trust conversation. If your professional is saying you need a trust for this reason, you need a trust for that reason, it's going to be in your will, or we're going to do a living trust and then it'll pour over from your will into that. All of that's fine if that's what's right for you. But you need to know why. You need to understand if they're doing a complex set of trusts, why are they doing it? What does that do for you? Don't just take, oh, you need a bunch of trusts and leave it at that. You need to know why, because the opposite of a will with a bunch of trusts is a simple will. And you might be a person that a simple will is perfect for.
And what is a simple will?
A simple will, I have a simple will. I will tell you that right up front. My will says I leave everything to my husband. If my husband dies before me, I leave everything to my children in equal shares. If one of my children dies before me, I leave their share and only their share to their children if they have any. If they don't have any children, everything goes to my living child. The end. End of the story. That's a simple will.
Okay.
And just FYI, this might be getting too crazy, too much information, but it's not personal. But unless you have $11 million, that's when estate tax kicks in. I wouldn't be panicking. Now, I don't know the rules in every state, obviously, and for inheritance tax, et cetera, et cetera. But in my state, unless you have $11 million or a need for a trust, and there are needs, I'm not saying there aren't, but I don't have that need, at least today, right now, then a simple will is right for you. And don't be making up things that I don't need or making me put things in a trust that's not necessary, that can create huge complications with Medicaid later if you're not talking to an elder law who specializes in this.
I think that sounds very reasonable. I know in my state of Massachusetts, estate tax kicks in at $1 million for the state. So, I mean, it's just another
that's inheritance
reason.
Yes, that's
inheritance. That's right. Inheritance
tax.
So
because in my state, inheritance tax kicks in at $1.
Okay.
Not for spouses. Zero.
Right. And I think that may be true.
So,
even
at $1 million, you might still need a simple will. I'm not licensed to practice in Massachusetts, but I'm just saying that's a good question. Why isn't a simple will right for me?
I think that's a great question. And it also points to something else. If you move, or if your parents move, you need to look again. Even if the 5 years isn't up, you got to look again.
That's a really good point, Lenore. I just had a gentleman contact. He saw me on television, which was absolutely fabulous. He said, I saw you on TV, and my wife and I just moved to Pennsylvania, and we need to do new documents. So how about that? And he was right. You do. You need to do new documents when you move to another state because the rules can be dramatically different.
Yeah, I think they are. Anything else that we should be thinking about while we're alive? Because we can't think about this when we're dead. So even though the attorneys that you're talking about are live people versus dead people, we can only make these plans while we're alive.
So I would first like to say that I love you all if you're caregivers, but you need to think about this for you. I'm talking to you, Lenore is talking to you, and you're thinking about, I got to do that for my mom. I got to do that for my dad. Again, you said it in the beginning of the conversation, Lenore, but I don't think we can stress this enough. You need to do this for you. When my kids were 18 years old, I made them sign powers of attorney before they went to college. They went far away to college. And I wanted someone to talk to me if they got in any financial or medical trouble. So these documents are not just for, quote, old people. These documents are for, quote, people.
Live people.
Really, all people.
Live people. Really, really good point. And still in this country, 50% of people die without a will. It means you're giving up control. Right. And if you are a young family and you have young children and you haven't appointed a guardian for your kids, you've made life more complicated than it had to be. So can't stress it enough, Cathy. I'm with you 100%.
Get you off the hook, quite frankly. They're going to haunt you because being irresponsible about this. And I know it's hard. I know, God, are you really adding one more thing to my plate, Cathy? And the answer is yes, I am. But I'm only asking you to do it once every 5 years. It's not even like 10 minutes a day, like exercise. I only want you to do it once every 5 years.
And you might not need to make any changes every 5 years. Everything might be fine.
And that's fine. You look at it, nothing has changed. This is great. You put it back in the underwear drawer.
Okay. I hope that we have created some clarity today where there was confusion. People are often reluctant to hire an attorney to deal with some of these planning issues. But as you have pointed out, it is so complicated and things change over time in your own life. And the laws change sometimes over time, and they differ from state to state. So really, hiring an attorney is an investment in your family's resources to understand the rules and set it up right. So I want to thank you for shining some light on this topic.
Always my pleasure for torch light.
Exactly. Listeners, thank you for joining us on Eldercare Illuminated, brought to you by Torchlight, the award-winning platform that helps people resolve family challenges, no matter the age, stage, crisis, or concern. See you soon on the next episode. In the meantime, you take care.
Thanks for listening to Eldercare Illuminated, a Torchlight caregiving podcast. Find other episodes of Eldercare Illuminated on iTunes, Spreaker, and Podcast Go. If you're interested in bringing Torchlight Elder or any of Torchlight's other caregiving products to your workplace, please contact info@torchlight.care. That's info@torchlight.care.